Let's turn that on. Okay, the meeting of the Legislative Committee for Monday, September 27th, 2021 is hereby called to order at 6:32 p.m. Let's do the roll call, please.
I can do it.
President.
Alderperson Bailey.
Present.
Alderperson Sarian.
Present.
Alderperson Collins.
Present.
All are present.
Okay, our order of business number 2 is the election of chairperson. Do I have any nominations?
I move that Alderperson Collins becomes chairperson and Alderperson Bailey becomes vice chairperson.
Okay, that's your nomination. I'll second that nomination. Any other nominations? Any other nominations? Okay, we'll have a roll call vote. I'll just say all those in favor?
Aye.
All those opposed? Motion's carried. Alderperson Collins is now the chairperson.
Okay.
Want to come over here?
Yeah. Do our little funky thing here. You know what? Why don't we?
No, you got the,
No, we have to do it the right way,
The
or
right
else
way.
we get confused.
and you have the gavel here. If Brian gets
Okay.
out of order.
Okay,
I
well,
mean,
I have to watch Brian. Thanks for the heads up on that.
I had to do that once at a school board meeting. The, getting riotous, and I had to bang the gavel.
Oh, jeez.
During Act 10, it got very voice
Sorry.
out of order, actually.
All right. Okay, thank you for the nominations. And number 4, approval of the August 26, 2019 Legislative Committee
I'll
minutes.
make a motion to approve those minutes.
Second?
Okay, I will need to abstain. All in favor?
Aye.
Opposed? And as I said, I abstain. Okay, passes. Number 5, discuss and adopt an ordinance to amend Section 21.04.90902 of the Municipal Code pertaining to decks, patios, porches, breezeways being permitted in required front yards. And I should read that. I'm sorry. PC 8, or is that Planning Commission meeting, 8/10/21? I don't need to read that, sorry. Never mind. The presentation, would you like to give that, Christy, please?
Thank you, Madam Chair. Alderperson Akers had requested staff to draft an ordinance addressing decks, patios, porches, and breezeways. We receive a handful. We have, on average, maybe 3, 4 is a lot, zoning board of appeals meetings per year. And sometimes those appeals are, for example, I had a deck in my front yard. I tore it down because it was rotting and I'd like to build a new deck. Well, when you tear something down and you construct something new, even if it was there at one point, you do need a permit for that. And when you apply for a permit, it triggers us to look at the code. Does it comply to the code? And so today's code does not allow decks in the front yard. It does not allow patios in the front yard. It does not allow breezeways in the front yard. It does not allow porches in the front yard. There are several of those throughout the city. You'll go see the older housing stock. They're existing non-conforming structures. They don't meet today's code. They don't meet today's ordinance. Back in the day, in the 50s, 60s, there was no code prohibiting it, so they were constructed. But this also applies to a homeowner who doesn't necessarily have a deck, patio, porch in their front yard today. They would not be allowed to build one without going to the Zoning Board of Appeals. So Alderperson Akers had suggested maybe these should be allowed in the front yard. And so, as my memo summarizes, after some consideration, staff's recommendation, again, just a recommendation, this ordinance, any ordinance drafted would need to go before a public hearing. It's in Chapter 21, our zoning code. Anything in the zoning code requires a public hearing. So we're just looking for some guidance on, one, do you want to draft an ordinance allowing these structures in the front yard? If not, then we just continue as is today. They're not allowed. If you want one, you go to the Board of Appeals. Or do you want to draft an ordinance that would make some modifications, allow all of these, allow some of them in the front yard? It's totally up to you. This is a policy decision. The Plan Commission did review it. The Plan Commission recommended no changes to the ordinance. Plan Commission said these shouldn't be allowed. They should go to the Board of Appeals if and when someone wants one, ask the Board of Appeals for permission. So it was discussed at the Common Council meeting, I believe in either July or August, one of those two meetings I was not at. Common Council recommended that it be discussed at Legislative Committee, so here we are. So again, this is completely a policy decision. You can pick and choose however you would like a version drafted. You direct me, staff, to draft a version of the ordinance, and then can schedule a public hearing, and we can go from there and then discuss it at the public hearing amongst all of the Common Council. Alderperson Akers was just talking about maybe drafting some language that existing non-conforming decks, patios, porches, breezeways, if they're in a poor condition where a homeowner wants to rebuild that non-conforming, draft language so that that would be allowed without having to go to the Board of Appeals, but only reconstruction of one-for-one replacement of that non-conforming structure. And then leave the rest as it is today. New ones would require Board of Appeals. That was her thought and just conversation that we were having here this evening. So I'll leave it open for conversation from there.
So when I read the stuff we were provided, the compromise, who wrote about the compromise?
That was just a staff recommendation from my part.
Which I thought, that sounded pretty good to me, in that the compromise would be to allow, what?
Excuse me, patios? No,
Patio-
porches and breezeways, which are
Right,
what you see in the front of a house, a porch, a breezeway.
Those in front
Yeah.
of a house, just like you
Decks,
just said.
decks are more of a backyard type of structure. Some houses do have decks in the front today. They're non-conforming structures, you know. They exist, but they don't conform to the code. Patio is more like a backyard type of thing too.
I mean, that's what I thought.
And-
And
oh,
then
go
I
ahead.
thought, well, okay, so if a home does have one of the other, you know, I guess it would make sense to allow them to rebuild it.
Yeah.
Right?
I would agree with the latter of what you said, being able to, if they're already existing, because I'll just give an example of a porch, mine. But no, seriously, I've lived there, as I said, since '69. When I was a little kid, and then we used to have, like, what are those caps, and we used to take stones and, make them go bang and stuff like that. Well, I've little divots in some of my porch. And the porch is there, it has to, it also supports like the overhang, but it's a porch. And it would be nice to be able to do that instead of having to go to a board of review. I mean, I'm not adding on a deck or anything like that, but, if somebody has something like that, it's so simple, get another slab of concrete put in there and, I would have to, not just because of me, but I could see that with other people too.
As far as a patio, I have a neighbor down the way that their garage is like a L-shaped. In other words, their house is set back, and their garage sticks out. So the garage is actually in line with the other fronts of the other houses. So it's a L-shaped like this, where the road is here. And they put in a little bit of a patio block, and they sort of sit out on there. So would that be allowed for them? Because it is in the front yard, although it's not, it's set back a little bit from the road.
Sure, I mean, you can pour a slab of concrete anywhere.
They have
They don't need a
They have-
permit,
have
so,
those decorative blocks,
sure.
the area, and they sit out there in their front yard.
Yeah.
And just off to their front stoop, there is a little patio area in their front yard. And to the left, of course, is the garage wall, but then they look out on the street. Would that be allowed?
I mean, it wouldn't need a permit, so there would be no Board of Appeals or approval from the city necessary for that.
What makes a patio where you do need approval then?
Yeah, no, that's structural patio.
Then, or didn't, I'm sure they didn't get approval, but
That's a good question.
Yeah, it is.
It's in the building code. Here you go.
Okay.
Every
stair.
outside stair, porch, deck, patio, I don't know if definition, that's not a definition.
must be an area maybe 8 feet by 8.
Maybe the size
feet.
determines it. Maybe the size determines if a slab of concrete is a patio? I don't know.
It is in their front yard. But because the house is constructed where the garage sticks out,
Okay.
in an L-shaped, because they couldn't fit the whole,
We don't have definition of patio in our
Oh, it
code.
doesn't look like we do.
And-
I think
and
common
cer-
sense kind of prevails, but
Yeah, I mean, certainly that might be a consideration as part of this, would be to add a definition of
yeah.
what any of these things, I think we may have a definition of deck perhaps, but if we don't, what the courts will do is, they'll look
But-
it up in
Yeah,
Webster's.
right.
That's what I'm
Bruce, I guess, we could all find examples of one of these anywhere in the city, right? I found a deck in the front. I found a patio in the front.
Right.
And it's just a policy decision. Do you want those in the front, though? I guess that's where we need guidance from you. And again, we can't judge what's tasteful. We can't talk about materials. And, this is kind of a yes, it's allowed, no, it's not. We'll get some ugly ones. We'll get some good looking ones.
Yeah.
And I think that might be why at some point they became prohibited in the front. I would imagine there was I could just see an example of where someone built a really ugly patio or like a deck or porch or something. And then a policy decision was made. We don't want to allow these in the front anymore, so.
So the Webster definition, number 1, courtyard, especially an inner court open to the sky. 2, a recreation area that adjoins a dwelling, is often paved, and is adapted especially to outdoor dining. Sure. So
I know I definitely
that's
have a
the
patio in my
determining
house.
factor. Maybe, would you like, an area or outdoor dining in the front of a home? Is that what we want in Greenfield?
I have no problem with having a patio in somebody's front yard. I don't see any harm to that. That's just me. So the compromise you mentioned,
But what is the difference between a patio and a deck then?
A deck is structural. You're building with wood and you have a foundation and,
Okay,
yeah.
all right.
And it doesn't have to be raised, usually you think a
No.
deck, but it's not.
Um,
It's not.
well, if somebody wanted to put out those blocks, cement, those, colorful foot-long blocks, and have aided, and sit out in their front yard.
What I'm going to suggest then, okay, it does have deck here.
Here's the definition
But
of
as
deck
if
in front of
we-
you.
Not a deck, it would be a patio.
Right, right. But thank you. But the other thing is maybe if we do put a definition of a patio.
Often
Would
serving as
be-
a member for strengthening the structure of a vessel.
Because now, what happened in Acres District
then, yeah.
that started all of this, that's considered a deck.
That was a deck,
correct?
yeah.
Okay, that's what I thought. All right,
A deck is an open outdoor porch or
Yeah.
platform without a roof that extends from a house. On the other hand, a patio is a paved
Right.
area situated directly on the ground,
Yeah,
which can either be attached or detached from a house.
yeah, the city's zoning code does define deck, and I have it here in front. On the screen.
Oh, sorry.
Although I might suggest even that definition needs updating.
I'm sure it
Yeah.
needs updating.
In
I'm
in
sure
light
it
of the fact
does.
that we say made of wood, and I suspect
Right.
there's plenty of folks that are using
Composite.
composite material now.
right.
Well, we are gonna just scratch this whole code eventually.
Promises, promises.
Basically, I'm for the less restrictive code here in regards to decks and patios. And if we end up with an ugly one somewhere, I guess but I think, we might stop people from having a more tasteful ones, than not. I'd rather have 10 tasteful ones, and if there's one that doesn't look so good, I'd rather not stop the 10 tasteful ones because one might look bad. That's my opinion.
Although, I mean, have you ever seen a purple house or whatever,
Yeah.
I know what you're saying, I can understand that, but one bad
But how bad can
looking
a
structure
patio
or something, I don't know.
be?
I don't, or, I don't know. I don't know.
Well, I mean, one of the historically, I would say probably both here and in other communities. I mean, one of the reasons that you make that distinction in terms of what you allow in the front versus the back is the recognition that things come with it. That just when you put a nice deck out, the deck may look nice, it may not look nice, but typically when you put a deck, then you have the lawn chairs that sit out there all the time, and umbrellas and the
Fire,
fire pit. Thank you. That's what I was thinking of. That then typically stays there and sits there. Whereas typically, on a porch type structure, that historically would have been allowed in the front yard, those typically have, some sort of either railing or wall that kind of blocks off some of that from view. They're also typically not as large, and so that it doesn't encourage the type of clutter that you might otherwise see. And that's really, I think, probably the goal behind why you look at what is or isn't allowed on either side.
What you have a recommendation?
I mean, I think that the proposal that staff has made, the compromise, seems to make some sense. It allows some use in the front, but maybe not a free for all, and it hopefully does so in a manner that is going to hopefully garner less complaints from neighbors than not. In terms of the rebuilding, I think rebuilding existing things, I think makes some sense in this case. They're typically small, relatively inexpensive. I mean, a porch typically is more expensive, but to just redo a deck is can be fairly cheap. So you're not really prolonging the life of the house or anything along those lines. So, I think that makes some sense too. So I don't see any real issues with staff's proposal, but obviously it's a little bit more restrictive than I think, you might be looking for.
That's
Yeah.
what I thought. I agreed with.
With the
Staff's-
compromise?
Yes.
But it does ban somebody from putting a small patio in their front yard. And if they wanted to do that, they'd have to get a,
Board of Appeals
Right,
approval.
I was
Board
gonna
of
say
Appeals.
Board of
So
Appeals
there's
they'd
a
have
way
to
to
come
do
to.
it.
There
you know?
is.
Right.
It's not,
as long as there's an out.
that's right.
Right,
If somebody would have put in, if you look at, Mr. Radner's house, who's very landscape beautiful, and if he might even have a sitting area in his front yard. If I remember,
no,
there's a lot of brick out there when
Yeah,
you walk in the front.
yeah,
It might be a couple chairs out there, I don't know. I'm not saying, but if there was something like that, and they had a couple chairs and a little table, and behind some, like, beautiful landscaping like he has, I don't,
Well, that wouldn't be a porch. It may be a porch.
that wouldn't be no,
No?
it was all, it's all, brick. He's got a beautiful brick walkway with,
Yeah.
in the front of his house with,
Okay, yeah, I
a lot
know.
of
Yeah.
landscaping and
I
stuff.
right,
So
right.
if he would put, a little table with two chairs or something, might be
I
against
think
our
that's-
ordinance, but maybe he could go, or somebody like that could come and get a Board of Appeals, so I'm fine with that
Yeah,
compromise.
and that's what I would think, that they would need to, I'm not saying, I think they should be able to come to the Board of Appeals, because it might look very nice, like you said, even that neighbor, and it looks nice. But, I don't think everyone should be able to, because it can also look like it's a parking lot or something, some people abuse.
Well, that
in
was
the
going to be
front
my
yard.
comment is,
Right.
sometimes location is everything.
Right.
And what I mean by that is that, where you have kind of like what you described, where you have the driveway and then there's some, space between the driveway and the front door, putting concrete, that matches the driveway, well, maybe that just becomes part of the driveway and, maybe we're not, as concerned about it. And so, there is gray area in this. I mean, unfortunately, it's very difficult to precisely define any of these terms: deck, porch, patio, breezeway. There's good. They're just by their very nature, there's gray area that's going to be involved, and so it may be that in a case like the one you described, where it's kind of between the driveway and the front, front door, maybe that's just extra driveway, and it would get approved in that way. And so, it's going to vary a little bit case by case too.
Right, and how much land there is. How much land do they have in the front or whatever, like, it would look very nice there. Is it necessarily going to look nice, like, across the street from here? Not necessarily.
Well,
And that's why you need, with the
my
Board of
neighborhood
Appeals,
is
somebody
is
to
the perfect
review.
example. In my neighborhood, just the way that it ended up being developed, the houses on the other side of the street from me have pretty steep backyard, and then it's very, there's kind of a drainage ditch along the property line. And so they don't really have usable backyards at all. And so everybody on that side, when they're going to be outside, relaxing, that type of stuff, for the most part, do it in the front. The only exception is if they have, if they're going to, eat outside or something like that. They all have picnic tables or, whatever in the back. But if they're just typically just hanging out, having the beer on the weekend with the fire pit, they're sitting in their driveway, doing it.
Sure.
Whereas, most of the rest of the subdivision, everybody's in the backyard because, you have usable backyards. And so those types of circumstances are the cases where a Board of Appeals case is probably appropriate, that there's a unique feature to my property that prohibits me from effectively using the backyard, and so I'd like to be able to do it in the front yard. And so you're able to make that case as well, so.
Yeah, stay flexible is a good idea. Okay, we're good.
Okay. All right.
So,
Well, how
Like
would,
marching orders are to draft with the compromise, but also add language about existing non-conforming decks, patios, porches, breezeways can be rebuilt, a one-for-one replacement, without having to go to the Board of Appeals.
And some definitions.
And
right,
some new
and the
definitions,
definitions,
yeah.
yes.
Yep.
That sounds good, yes.
That
Is
sounds
that-
good.
Am I
Yes.
reading that correctly?
Yes.
Yes.
Okay.
Yes,
Okay, thank you.
okay.
All right, I'm gonna sneak out, if that's okay?
And is there, do we do motions with this?
no,
or not?
you don't.
We
You-
just discussed?
Certainly not for
recommendation.
this
It's
one.
new,
No,
okay.
Certainly not for
Because
this
we're
one. This
just
was
under, okay.
Yep.
It's discussion, okay. Thank you. Thanks,
I want you
Christie.
to stay. No, I'm just kidding. No, no,
Go,
just,
Christie, thank you for coming. We appreciate
you.
you being here. All right,
okay, thank
so
you.
now we are at number 6,
6.
regulation of electronic scooters. Ryan?
All right. So just very briefly, this is before you because the city has been approached by, I think it's Bird scooters with the idea that they want to start operating in the city. Effectively, Bird has kind of changed their business model a little bit, and what they're doing is, trying to almost make it a little bit like a franchise where they, sell areas to individuals, and so in the interest of just trying to get folks and have areas, they've approached the city about operating here to utilize the streets or whatever. The statute a couple years ago changed to allow us to regulate them, either just in terms of use, prohibit on-street, off-street, what type of streets you would allow it on, those types of things, or even to regulate the actual business of short-term rentals. So obviously, again, my neighborhood, there's a couple kids that have these types of electric scooters that are zipping around.
Mine too.
And they are private. That is the first type of regulation, would apply to. We require it to be on streets that are less than 25 and you stay off sidewalks or, whatever the case may be. And then the rental, is the actual operation of the companies. The companies, I would tell you, are generally considered to be, in, I think, most communities, more of a nuisance than not. We're not like downtown Milwaukee where there's, some need to, be able to zip couple blocks over on a scooter. We don't really have that necessarily here. And so I question how valuable it would be in the first place. But B, we're also not really designed for that. We don't have really wide sidewalks and terrace areas that are paved with concrete where they can store these things when they're not in use. So you're either storing it in grassy areas or on the sidewalk blocking traffic, those types of things. My personal recommendation, what I was going to propose and draft, was a set of rules that pretty much mirrored what Brookfield has done. That you limit it to very specific instances, 25 miles an hour or less on the streets. You require it to be on the streets, keep them off sidewalks because of the hazards that they present, and then to prohibit the actual operation of rental within the community. The mayor thought that we should talk with you folks first, and so that's what we're doing. But that would be my recommendation, would be to follow that approach. But obviously, happy to draft whatever. I did give you the example of Wauwatosa, which I thought was one of the more comprehensive approaches to regulating the rental and use of these things. That certainly could be an option, or we could pick something in between as well.
So regarding the rental, what would your proposal be?
My proposal on rental would be to not allow for rentals within the community. I just don't see a real value to them here, given the layout of the city and those types of things. I think they tend to be more of a hassle or a nuisance than they are of benefits. And so I would not recommend rentals, but certainly you could allow.
I know, I feel pretty much the same way. And if in the future, maybe we can always change this. But I don't think we're set up. I don't think the city really is set up for this. If we do have them, maybe in the, you know, is it Brookfield? Do they have, I don't have my notes in front of me, I apologize, where they have the 25 miles or less, you can, right?
Yeah, so the
Like in our individual neighborhoods, like, fine, but,
yeah, I mean, basically, the statute effectively allows at all times operating them on 25 mile an hour or lower speed limit streets. We can't prohibit that. We can't just say you can't operate them at all. But we can prohibit them from being on higher speed limit roads. Again, I think the idea behind the statute is to try to eliminate the conflict points, whether it's scooters and pedestrians when you're dealing with sidewalks or bike paths, those types of things, or scooters and faster moving vehicles. You know, hard to imagine a scooter, you know, zipping down, you know, Layton Avenue, you know, for example. Although there are parts of Layton that have pretty wide shoulders, so maybe that wouldn't be the best example. Zipping down 27th Street.
Right.
You know, I mean, there's no shoulder. There's,
Right.
you know, it's just not a good circumstance for that.
Okay, so, excuse me, so can one ride a bicycle on 27th Street? Mm-hmm. See, at first I agreed with that, you know, why don't we even need them, you know, and more accidents, you know, it's just a headache, you know, I wouldn't. But then now it just hit me, well, we can ride bicycles, why can't we ride a scooter? You can ride motorcycles, bicycles. Is there a reason? Why is a bicycle better than a scooter? I'm asking, I'm not, you know.
I think
I'm
you
not
could see a bicycle better than you could somebody standing on a scooter. I'm just saying, and those, yet seeing a bicycle and even a motorcycle.
You know what?
People.
See
you
now,
know.
okay, you know, I keep getting, now, a scooter, and I even looked up those, a scooter is the thing that you just stand on.
Yeah, like a
Right.
Yeah.
skateboard.
Okay, now, yeah. See, I'm thinking of a scooter as, you know, in Europe, they're all riding these scooters. It's
Oh,
like
yeah,
a
the
mo-
the little
not
Vespa
the
type
motors-
things.
Like
Yes,
little,
that's what I
no,
keep
No,
thinking.
no.
Just stand. and you-
Yeah,
Yeah.
So by rental, if somebody wanted to put up a station at 84 South to, you know, that's what we're talking about. Those are these stations where you put in your car. We do that when we go to Minneapolis. There's a nice park we go through there. So if somebody wanted to do that, we're outlawing.
Yes.
We're not allowing that.
Right.
If somebody wanted to do that and then go down Layton Avenue from 84 South to 92nd Street, down 92nd Street, which now was repaved and it sort of has a bike lane, and then go into Whitnall Park, you know, they wouldn't be able to.
But you're not supposed to be on the bike
They wouldn't be able to do
lanes.
that.
They have to be in the roads.
right.
Well,
Bike lane.
Well, if you had your own
That's on the
scooter,
road.
you can have your own scooter, but I guess with these things, when you rent them, they just leave them all over the place.
Right.
They leave them on
You
the,
have to put them back in the thing. Otherwise you get
I
charged.
guess people don't, yeah, I guess they don't.
no, the particular ones that we're talking about, the ones where you kind of drop it back off at a station, are typically bikes. The scooters, you know, and actually I should have thought as I was in Bayview this afternoon, met some friends for lunch down there, and as I was driving back to the office, as I was going by, I saw 4 or 5 corners where these scooters, as I was going around, were just, you know, sitting there. Yeah,
That'd be
Okay.
yeah, effectively what they
a business, a actual business box store business.
Yeah, I mean, the scooters, basically, it's all done on an app on your phone. And you rent the scooter, you punch in the number of the scooter, and then it unlocks it through the, cellular network or whatever. And then you can ride it. And then when you're done riding it, you just leave it where it is. And then what these companies typically do is they incentivize folks to then, often the one who has the area, to go out at night, collect all of them, plug them in, charge them for the couple hours that they need to be charged to, juice them back up. And then in the morning, they go out and put them back in their, starting positions where they like to, kind of start with them during the day.
I say, I agree. I say that we don't need them. We don't need any rentals,
So you
of
like-
scooters in
Yeah.
You
Greenfield.
like her,
Yeah.
Brian's proposal?
Yes.
Right.
Which is the Brookfield one.
Yeah.
Oh, okay, I'm good
Yeah.
with that.
There was something in the Brookfield, I don't know, there was something that I said, well, we don't even have that in Greenfield. I don't know what it was. Maybe it was the type of roads or something. I don't know, whatever. But you're going to write it so it makes sense to Greenfield, I'm sure, so.
Right.
Okay.
Okay.
Okay. All right. That sounds good then to you, Brian?
Yep,
All
that
right.
works.
Perfect. Okay, how up now, number 7, an ordinance, sorry, I'm getting old. All right. An ordinance amending sections 10.31 and 10.32 of the Municipal Code of the City of Greenfield as it relates to sex offender loitering and residency restrictions, and creating section 1.35 to create the Sex Offender Residency Appeal Board. Brian.
All right. So this is something that's been a little bit long time coming. This was something that we actually were looking at potentially doing just before COVID hit. And then with COVID striking, we kind of called timeout on it. Primary reason, although notwithstanding the fact that there's nobody here, when these codes were initially adopted, they were very popular. Lots of folks that came out and spoke. In fact, Franklin was one of the first ones to adopt it in the area. When they held the hearing or the meetings on these ordinances, they actually ended up renting out the hall at the big exposition center at State Fair Park and held them there.
really?
Because they had that many people. And so, we figured doing it in the middle of COVID might not be the best politically sensitive message, and so we kind of called time out. And now that we're obviously post-COVID, or at least back to more normal post-COVID, figured it was time to bring it forward. We do have folks that continue to ask about residing, so it's really just a matter of time before we get sued. We do have one individual, for example, right now that is in a location that is technically not allowed under the code, but we have not enforced that against him because his attorney has basically said, I will sue. And quite honestly, if he sues, he will win, and we will pay lots of money in attorney's fees. And so it's time that we update it and take a look. And so when we look at how we update it or what we look at, there's a couple things that we did, that we propose to do, at least in the code. So the first is that we kind of clarify and tighten up the definitions of what are the protected locations that we have. So, for example, we had swimming pools, but we didn't have necessarily other aquatic facilities. Not that we necessarily have one now, but you look at the splash pad, for example, that they just put in at Drexel Town Square in Oak Creek. That would be a type of facility that I think should be protected. And so we want to, be a little bit forward thinking when we draft these things. And so we changed the code to include other aquatic facilities to allow us to do that. We talk about recreation trails. In one of our other communities, there became a debate of, what is a recreation trail? And so we, better define that to be really like the Oak Leaf Trail,
Right.
type of a thing. It's not going to include on-street bike paths, and it doesn't include sidewalks, which, in
But
some
it
cases.
will include the Oak Creek.
It would
Right,
right,
perfect.
to do that. We, with respect to schools, COVID opened our eyes a little bit in terms of what school potentially could mean. And so we clean up the definition of schools to reflect that it's really just the physical school location, not, when we're all working at home.
Right.
All of the individual homeschool locations that might otherwise be there. And
Okay.
And then the last one is really just, we eliminate the word daycare specifically from the list of places. The only reason we do that is because the next couple sections down defines what a daycare is. It's a state licensed facility and all of those things. And so, that's kind of the first change that we look at, is just trying to clean some of those up. When Roger drafted the code, initially, I think he did an actually pretty good job. He really focused a lot on some of the things that I think are the locations that unattended children would be at. There's other communities that just, you name it, that, a golf course, how many kids, go hanging out at the golf course alone these days? It's, there's just there were lots of things that maybe needed to be cleaned up, but Roger did a pretty good job. So, I think the cleanup here was relatively easy on that point. I think you might have had a question.
Yeah, homeschooling. I understand what you're saying now about, well, during COVID, now everyone's at home. But, historically, there are homes that are licensed for homeschooling, or they don't really have to have a license, but
Yep. So
homeschool.
Yeah, so there's two issues with the traditional homeschool that you're talking about as it relates to this ordinance. The first is just the difficulty in highlighting that location as somewhere that an offender should be attuned to be thinking about. It's not really any different than any other home. It just happens that they don't send their kids to school; they do it in their own house. So there's nothing that really signals to the offender that, hey, maybe you should pay attention to the fact that you shouldn't be looking at this house, other than going and looking at the map itself and doing it. That's the second problem is that in order to keep that list current, somebody needs to go through on a semester by semester basis and see who is and isn't in the homeschool, because it changes every semester. That you'll have somebody that'll stay home one semester and then they'll go back to school the next the next semester, or they'll stay out 1 year and then they move back into the district the next year, or they just move and nobody knows. And so it becomes really a lot of work, not only for city staff to update the map by highlighting them and then doing it, but it also creates work for the school district, because they then have to run the report, send it over to us, and to do it. And so it's very difficult in terms of a workability perspective to include those.
Okay.
All right. So that was the first thing. The second thing, we just kind of modernize the purpose and intent language that was already in the code. We really expanded a little bit more. Primary reason for that is because case law and the experience that communities that have been sued tells us is that, the court is in a lot of ways going to defer to your ultimate decision. They trust you guys to do the work. That's why I included all of those, readings for you to do, because the court assumes that you're looking at it and weighing the various options and looking at it. And so by specifying in the code itself, hey, here's all the things that we believe, it makes it a lot easier for the court to say, yeah, they really took their job seriously and they know what they're doing. And so, that's really why that section was then expanded. In terms of what's there, we have a small cleanup where we had in one section where we say that a map is going to be in the clerk's office and the police office, and then we say it again a couple paragraphs later, so we just clean that up. We only need to say that once. we clean up. We had the legal guardian and guardianship issue. We just clean up the language there a little bit because it wasn't super clear with what's going on. Then we add the appeal process. The appeal process is, I think, the kind of key component to what we've done here. This is really kind of the, I don't want to say the saving grace, but I think it's the most critical component of what we're doing. And effectively what it says is that if an offender wants to reside within the community in an area that they're not supposed to, that they have the ability to come to this board and make their case as to why they believe an exemption should be granted. That here are, the factors that we've determined. So just as a for example, I had my first one of these that I've done personally just last week. The facts of the case were that the offender did some very, very inappropriate stuff with his siblings. In essence, modeled the behavior that was treated to him. He had also been abused, and so he just kind of modeled what he saw with his brothers and sisters, or brother and sisters, I should say. Fast forward, that was when he was, I think, 12, if I remember right. Fast forward, he's now almost 30, and is married, has kids of his own, has been an upstanding citizen, no law violations otherwise. He came in to make the case that he should be allowed to live in an area that would have otherwise been off limits for him. And so the board held a hearing and considered all of the various factors that we spell out, and ultimately in that case ended up granting the appeal. I think in large part because of the fairly significant period of time between the offense and where we're at. And so, it's that type of individualized analysis that I think the courts ultimately look to say, this is not just a pure banishment type situation, but this is, really keyed to and tuned to making the best choices to protect public safety as you can, because not all offenders are going to be the same. And so you're going to recognize that and then make decisions based on the individual as opposed to just blanket saying no. And that, I think, saves the day when it comes down to it. So with that in mind, and I see that Denise, you have the map up, or you did have the
Yeah, I
map
did.
up.
I'll bring it back. Yeah, that's.
One of the things that we talk about in the memo is the distance. Now at 1,000 feet, and if you look at the map, we are in terms of a community probably far better off as the starting point than a lot of communities were. There were communities that were at 2,000 or even 2,500 feet.
I know we struggled over, because I remember when we wrote this.
Yeah.
I don't know how many, but, I mean, we really spent a lot of time and energy on this.
This is
You know,
where my
we
concerns are.
We really thought about it a lot.
Yeah, and so there's kind of competing schools of thoughts. I mean, I think 1,000 is probably a very good starting point because you're less than what the state does for the sexually violent predators, and so you're something less than that. If you look at the map, there's actually a large portion of the residential pieces of the community that are open and available to folks to potentially reside within the community. And so I think that it really isn't a terrible starting place. The unknown that we have is that we don't know what the courts will think about it. And my partner in the office, Jesse, for example, he is of the belief that if you have a code and a distance that excludes 50% or more of your residential units, that you're just going to get struck down. That's his belief, and so he's drafting his amendments to reflect that. That's, Hales Corners is one of his, for example. You see that they're, very low at 500 feet, I think, or something like that.
So small.
So he's a big believer in that is the case. I don't share that opinion. I think the court ultimately is going to do kind of a totality look. They're going to look at the map and see, how much of the area is otherwise allowed. And I think that the appeal process becomes the saving grace. That even though you've said no, you can't live there, that because you have the ability to make the appeal, that perhaps it's not as bad as it maybe looks. Now that said, he may be right. And the thing we were not able to do, we're actually struggling a little bit with identifying some of the daycares right now because we were trying to update the map. Then try to do the calculation about, where does this map put us specifically? And unfortunately, we just don't have that yet. They were still trying to place places on the map, and so we don't know for sure. I mean, if you eyeball it, I think we're pretty close. Is my sense when you eyeball it.
To what, 50%?
To 50%, yeah. And so, with that in mind, I don't know if I recommend changes on it, but certainly that might be something that perhaps the discussion is, maybe we get that number and at least present that at some point so that if we want to consider, reducing it to make it less than 50, that it makes that a possibility. As I say, I don't know that I recommend it. I look at the map. I'm not overly offended by the map, like I am in some communities. I think, with an appeal process, I think you're okay. I think that saves you from some of the pure percentage type discussions. But again, until the court says, no, it's got to be less than 50, we're just guessing.
So to refresh my memory, what is it? So it's 1,500 feet, the radius of, like, this is a school, and
Yeah, basically, the way it's calculated is you take the property line of the school, and then you go out 1,000 feet from there. Is the
1,000, that's
Yep. And so, and then if your property is within that, then you're counted. So if you had, for example, let's say this was your property, and the line came in here, but your house is here, you're still considered within that zone because your property is within that zone. And so it ends up being probably a little bit more than 1,500 feet in a lot of cases because you're going to the edge of the property. Yeah, it's, so, my recommendation, I guess, would be if you're looking for a recommendation, would be to, at least for now, leave it at the 1,000 with the understanding that as this moves forward to council, that we'll have that percentage information and maybe, have a recommendation to tweak that as we, move forward. If when I look at the map, I say, it looks almost 50%.
Yeah.
And it turns out that it's really,
good.
60%, then maybe we want to adjust that number a little bit. And of course, we can, if we get to that point and we're going to make that recommendation, we'll have the new map too to show you what the new map looks like so that you can kind of weigh that as well.
And this appeals board that we would set up,
Yep.
it's not going to be the board that we have right now.
Correct. It would be a different board.
Okay. Who would this consist of? I take it you?
Nope, it would be just 3 citizens from within the community. We've done it in kind of differing ways in different communities. There are some communities that do it just purely with the kind of the Board of Zoning Appeals. This isn't really a zoning issue,
Yeah.
but some communities their Board of Appeals is both the Board of Zoning Appeals and the Administrative Appeals Board. And so they kind of have both. We don't have an Administrative Appeals Board here, which is fine. We, by statute, we can kind of opt out of that process. In fact, you see the language within the code where we specifically say we opt out of it here. So that's fine. But you could still assign it to those folks if you wanted to. Another approach is the approach that you see here, that you create a new body, and you just make appointments of citizens. The number typically is either 3 or 5. I've kind of seen both of those. I haven't seen anything above 5. Just the reality is it's hard to find volunteers for stuff.
I'm sure.
So that's one approach.
This is gonna be difficult.
Yeah.
Who wants to decide?
Well, we do have a Board of Appeals, right?
Yeah, but you want it different. This is a whole different
No,
matter.
I would
This
like
is
to
different.
see, like, psychologists, social workers,
Yeah,
on this board.
Attorneys.
That would be my idea.
or attorneys
get 'em.
even.
Well,
I don't know.
Yeah, and so
That's
the third approach that we've seen, and it's actually the approach that we came up with in Mequon, which was really designed primarily because they, like here, have a very difficult time finding volunteers. And the reason I didn't, well, we'll come back to the reason why I didn't propose this here. But what we did there is we just create an ad hoc board every time we get an application. And the default membership of the board up there is the mayor, the common council president, and then the chair of the public safety committee. Now, we don't have a public safety committee, so we'd have to pick the chair of one of the other bodies to do it. But that's the default. But each one of them has a period of time within which, once they're notified that there's been an appeal, they can then themselves appoint somebody in their stead and say, you're the person that I want to have hear this so that it's not me. That worked, that the one I just described was in Mequon, and it actually worked pretty well. We were able to find folks actually within only a couple days of having the hearing, notice that it was coming, and it worked pretty well. The primary reason I didn't suggest that as an alternative here is just the reality that the chief, other than the guy that was actively asking to reside there,
Right.
couldn't remember the last time he had even been contacted about somebody living in Mequon. The reality is that it's expensive to live there, and most offenders are probably not going to be able to afford that. The reality is that here we have requests fairly regularly. And so I do think that this is a body that probably will meet, a couple times a year, probably, 1 or 2 times. And so I think, with that type of body, it probably makes sense to create somebody that's going to then, be able to get up to speed and kind of have some experience and knowledge as you're moving forward. Now, we didn't specify, to your point, I would agree. I mean, if you could find, attorneys, psychologists, those types of people, that'd be great. In fact, one of the people that one of the alder, the chair of the public safety, actually, no, she's the president this year. The common council president found up there actually happens to be a former Milwaukee DA who prosecuted sex crimes. And so, and so she knew,
again.
a lot of the background and the details and the, the stuff that we were talking about. She was invaluable to the hearing process. Obviously, we didn't specify that because you don't want to end up in a circumstance where if you can't find that person, then you don't make an appointment, and then you have a vacancy, and it just creates problems. And so I left it generic just for that reason.
Which is probably a good idea.
So then the last kind of piece to this whole puzzle is the kind of last section of the code provisions that we adopted, which relate specifically to the Chapter 980 violators. Those are the sexually violent predators under statute. What was happening was that as all of the communities around the state started adopting these codes, the state started figuring out that they were having a really, really hard time placing these offenders on their supervised release. There just wasn't places to do it. And so they went to the legislature, and the legislature changed the rules that said, we as the local community don't get to have anything more restrictive than what the state says, and then they created their own set of restrictions. So for those individuals, it's 1,500 feet, so it's a little bit more distance than what we have, but it's less locations, and so it's really just the schools and daycares and I'm drawing a blank on the third one without looking, but it's a very limited set of locations that it's limited to, and so it does potentially open up the community. Now you saw parks, yes.
Sorry.
Now, obviously, you saw in the packet was the journal article from just a couple weeks ago. Even that rule is being challenged. That what they're finding is that the rural communities that don't have a lot of schools and a lot of parks, it's real easy to place people because there's just no limits. You get into cities and villages, and now all of a sudden it becomes more difficult because and so there's an equal protection claim that's being made in terms of how that's going to play out, and we don't know. But the real question is how we deal with those within our code, at least based on what the statute tells us today. We may need to change it if the courts rule against it, and that's fine. We'll fix it and do what we need to do. But the statute right now says that we can't be more restrictive, and so we, in some ways, are less restrictive. We're only at 1,000 feet, not the 1,500 feet, but we include additional places that the statute doesn't. So I think in total, the court would probably say our code is more restrictive. So the way we can deal with that is, kind of one of two ways. One is you just basically just blanket exempt them and just say this does not apply to Chapter 980 folks. The other approach is what I've
I understand that. Did you just,
that all of the residency rules that we have just don't apply to those people. That the statute applies and we just don't even get involved. And so that would be one approach. The approach that I've proposed and what's in the code is that we effectively just adopt the state language as our code as it relates to those offenders. And the reason that I make that recommendation is because what I've heard from a couple other communities is that where they didn't have that language within their code, when the state came in and said, oh, we'd like to place them here, and it was within an area that they probably shouldn't have been anyway, the court just kind of said, yeah, you don't have a role here, go away, and didn't listen to the city's concerns. And so I think by adopting the state language as our restrictions for those individuals, it at least gives us a better argument that we have standing in those types of placement circumstances, that we can go in and say, no, judge, this is what the law requires, this is what the statute says, this is why this is not an appropriate location for that individual, and then make the argument based on that, and hopefully have a better chance of being heard in
so
that
you're talking
case.
about now the most serious offenders.
Right.
Okay, so our code is more restrictive than the state's,
Right.
the state's code. So, and it's more restrictive because of the 1,000 feet instead of 50?
No, we are more restrictive because we include more places that we
More
calculate
places.
from.
So, all we'd have to do is eliminate those places, the more places. So the places that we include, that the state does not, are what?
Swim.
I didn't read everything about
Nope,
the sex.
nope, that's all right. No, yep. So the places that are not. So here's the list for what the statute allows, what the statute says they are calculated from. Yep, from any property that has a school premises, a child care facility, a public park, or a place of worship, or a youth center.
Okay.
Okay. What our code is a public park, which is one of them, a public swimming pool or other aquatic facility, which is not one of them, a public library, again, not one of the ones that's there, a recreational trail. Maybe you argue that that's a park, so maybe that's included, maybe it's not. It's not real clear. But you have that. We say a public playground. I don't know what the difference between a playground and a park is. It's probably the same thing in my mind. So I think that's probably included. Schools we include. Athletics fields used by children is something that deviates from what the statute says. And then we have specialized schools for children, which would include dance academies, gymnastics academies, swimming schools, those types of things. And so there are things that, at least in my estimation, are places where unattended children probably tend to go and hang out. I guess the question is that enough? I mean, certainly an approach to the problem would be to just say, our list of facilities is the same as the state, those 5 things that we read off, and just leave it at that. And then we could stay at 1,000 feet and we're fine under the statute and we don't need a special provision at all as it relates to it. But if we want to keep some of those other things or all of those other things, then I think we need the special provision that just says for these individuals, this is the set of rules that applies, and then just adopt the state rule. Does that make
What do you
sense?
think? I think your additions are valid. I think if we go a little more restrictive than the state, we can justify that. If it comes to that, I think what you're proposing is a good idea.
I do too. I'd rather have you say trails.
Do you think you'd feel comfortable saying that even though we are more restrictive because of those additional places?
Well, we addressed the being more restrictive by adopting the special provisions that apply just to those individuals. So what ends up happening is we have 2 sets of rules. You'll have the set of rules that apply to the regular sex offenders, and then you'll have the set of rules that apply to the folks under Chapter 980 release, the supervised predators, effectively. And those sets of rules will be a little bit different, but the basis for that, in my mind, why you justify those differences is that the guys that are here in the 980 are also under supervised release. So they've got typically counselors that they need to go see on a regular basis. They've got, folks from Department of Corrections that they're checking in with on a regular basis. They have very strict rules that are in place with how they need to be dealt with, which is not always true with the regular offender. Now, sometimes the regular offender may still be on probation, and so he'll have to go, check in with his PO once a month or, whatever. But the level of supervision is much lower, even under probation on a regular offender.
So do we not distinguish, in our code now, as it stands, we don't distinguish?
No.
Okay.
No. So that distinction would be a new thing that we'd add to the code.
So how would we set up this board, once we pass your change in ordinance here, it's gonna go to the council, and then we'll have to figure out somehow to get this board operational.
Yep, and it'd be really just the same way that any other board is done. The aldermen identify folks that might have some interest. Certainly, 2 of the members, for example, in the Mequon one we just had, are actually members of the Board of Appeals, 2 attorneys that the mayor and the chair of the Public Safety Committee reached out to them and just said, hey, you guys are smart guys. You're kind of used to doing these types of hearings. Would you have some interest in serving here? And two of them said, yeah, we'd be happy to. So that may be, we may, look to them first to say, hey, is this something that you might consider? If not, we'd have to find other folks.
So no, there is no appeal mechanism right now,
Correct.
Right.
so we wouldn't know, we wouldn't have an idea, no track history of how many cases. You say 1 or 2 a year, maybe.
Yeah, I mean, that would be my guess. As I say, we do, as I understand it, have fairly regular calls to just say, hey, we're thinking about living in the community, what are your rules? Of that, there's a smaller number that actually then move forward to say, hey, we'd like to move within an area within the community that we're allowed. If you allow for an appeal, that number might be a little bit higher than it is now, but probably not significant. But I'd say, at least as I understand it from what I've heard from the police department, we'd probably have 1 or 2. Probably a year would be my guess. Whereas in Mequon, if I had to give you a guess, we had one on Thursday last week, and that'll be the only one we'll have for probably the next 10 years.
Okay, sounds good to me.
Yeah.
Boy, we're easy. We're an easy
We're
bunch.
easy.
Well, as I say, I mean, Roger did a really great job when he drafted it, and it sounds like you folks as well struggled with it.
Yeah, I wasn't on board then, but I know that it was quite controversial, too.
Yeah, and so Roger did a good job. He, I think really had his pulse on kind of what was going on, and did a good job. Whereas I think a lot of other communities did what a lot of municipal attorneys do. Hey, my council's saying they want to adopt this type of provision. Who's doing it? And then you get the copy of who's doing it, and you say, yeah, that looks good. And you don't give it any thought, and so then you end up with a whole bunch of communities that have 2,000 feet restrictions because nobody looked at it and analyzed, is that the right number?
Sure.
Obviously you have other communities too, that, Mequon is one of them. That even though my recommendation to them was to drop from the 2,000 that they're at presently, they chose that they were willing to take the potential risk that's there. Now, they kind of like here, because they're so spread out, 2,000 feet maybe makes a little bit more sense because you're not, with one swath, you're not looping out 1,000 houses. You're maybe looping out 6 houses, and so they're counting on the fact that their map, when you look at the map, is not a you can't live anywhere, but there's places that there's options, and so
Okay, so I'm clear about this now. So are we going to change what our ordinance says for the non-serious offender? So we're going to only have we're going to have less places. Is that it? Because now we have more places for.
no, I think that
We're going to leave that as it is.
Yeah, I mean, what we're doing is really just kind of cleaning it up. We don't necessarily reduce. In fact, we probably add places because we add the aquatic facilities. Again, not that we have any, but they could exist. The only real subtraction that we make is that we classify a recreational trail to be just the physical trails, not bike paths on the road, not sidewalks. So that would be a reduction potentially, but if you look at the map, we're clearly not showing on-street bike trails as counted anyway. So it's not that we're actually reducing anything in practice because we've never been calculating it that way. We've just cleaned up the code to make sure that there's no question that that's what we mean.
Okay. Then I'm still a little confused then now. For the more serious offenders. there are going to be less places? They're going to
Be,
be more places?
nope, there'll be a couple fewer places, so you wouldn't have pools and aquatic facilities, you wouldn't have the library, you wouldn't have athletic fields.
So we're going to say that the more serious offender can live in more places than the less serious?
No.
In effect, that's what you're saying.
Potentially. Now, remember, you're also increasing the distance, and so it's gonna, I mean, without overlaying the maps, like, I can't tell you for sure how many more places they would be allowed to live. But as I say, the reason for that,
Yeah,
is that they are under very strict supervision. I mean, they've got typically ankle bracelets, they've got regular, doctors and counseling appointments that they're going to. They see their, their Department of Corrections folks are actually, typically it's a member of the Department of Health Services. Actually, it's not even a Department of Corrections member. They typically see them on at least a weekly basis in most cases.
oh, I think this doesn't maybe make sense. Even though they're supposed to have more
Right.
supervision and monitoring, but in effect, hey, sometimes that doesn't work. Do you understand what
Yeah.
Yeah, no, I mean, I certainly, understand the idea, or the concern. Unfortunately, it's us trying to deal with the statute the best we can. And as I say, to me, the basis is just the level of supervision that they're under. And it, certainly one of the end effects as we spiral down, years from now, of the very concern that you have, is what happens to the guy who moves in when he's under the state rule, and then he's now no longer classified under
That was
Chapter
my next-
980.
that was my next question.
How then do we deal with that? And right now the answer is you got to move.
Yeah, see, that's what my,
Or file the appeal. And certainly one of the basis for your appeal would be, look, I've been here for 6 years while I was,
Right.
so you have the ability to make that case. But it is a weird situation that potentially will arise. Now, the reality is in most cases, unfortunately, of Chapter 980 individuals is they reoffend in some way, or they don't follow their rules of what they're supposed to, and then they ended up getting recommitted. So it's a problem that realistically, hopefully, knock on wood, we'll never see because of just the nature of those offenders. But it certainly is a question. But as I say, the appeal process would be their real option, would be to say, hey, I've been here for, whatever number of years. Here's why I think it's appropriate for me to continue to live in this location. And then the board can make its decision. And if they say no, then they got to move. And in today's real estate market, it's real easy to tell somebody that. In a tough market, it'll be a little bit harder to tell somebody, hey, you got to move. But the reality is that they're probably not owning anyway; they're just renting. So
Yeah.
So a lot of cities are setting up this Board of Appeals.
yeah, I would say that is. I mean, the Pleasant Prairie case that all of this kind of stemmed from, pretty much blatantly says that one of the problems with Pleasant Prairie's ordinance was the fact that they had no method of doing an individualized assessment. And so I think anybody who reads that case and concludes that you can get away with not having an appeals board where you offer that individualized assessment to somebody who wants it, I don't know how you read that case that way.
So the court cases are sort of saying, you better have a Board of Appeals.
Yeah.
Oh, definitely. I think that's,
Okay,
I'm 100% on
I'm good
that.
with that.
Yeah, and like I say, the one thing unfortunately the courts haven't told us is if there is in their mind some percentage that, is the magic number. And so we're just kind of, speculating on that. But as I say, certainly as we bring it forward to council, we'll hopefully have that answer of what the percentage is. And then if it's, much higher than what I think it is, we'll probably have a proposal that we reduce it and the corresponding map just to, so that you folks can see what that looks like, so.
Okay, I'm good with that. His proposal.
The only thing I have a problem with, as I'm thinking about it more, is that the more deviant offender is going to have less restrictions in.
Well, the other thing that I will say is that the statute, and let me look at the language here exactly, but there's actually two classes of offenders under the state rule.
I mean, doesn't make sense when you think about it.
Yeah, so if,
Because I don't care, you say, yeah, they might, they're gonna have, ankle bracelet. I don't care. I don't wanna wait till it happens, they're gonna, cause the recidivism rate is, high. Well, why is that? It's,
Yeah.
it's because maybe even with that ankle bracelet, they do something wrong again. And I don't wanna wait till it happens, and then say, oh, well.
Screwed up.
Now you.
Yeah, so there are two classifications under the statute. There are those that are just under supervised release under the program, just generally. And those are the ones that have the kind of rules that we talked about that apply to them. There's a second category that is folks that are on supervised release, but for which they're, what statute says is that they are, a serious child sex offender, which effectively is somebody who has an offense that the victim was under the age of, I think it's 14. And if it's somebody who falls into that category, then in addition to the rules that we talked about, they also cannot live next door to somewhere where a child has a primary residence. And so they are that class of offenders. Now, admittedly, there's, I don't know what the percentage is, but if the idea is that we're really trying to protect the youngest folks within our community from folks who have that inclination, then the guy who's had that violation already is not going to be able to live anywhere next door to where a child presently lives. Now, obviously, if they live there and somebody comes to them, then they're grandfathered, and so it's a different situation. But as long as they can't move into a situation where they live next door to a child. And so, at least those offenders do have significantly more restrictions than what we have. It would be the ones that, their victim was in that 15 to 18-year-old range that have a little bit more flexibility, but they're under supervision. And I know obviously you never know. You're right, in terms of what happens. But I will tell you that the courts and the DHS, the Health Department, and Department of Corrections really take the monitoring of these folks very seriously because they recognize all it's going to take is one really bad case, and the public outcry to deal with these folks is going to be through the roof. And so, it's trying to balance those the constitutional rights to just being a person in America versus we're going to banish you forever because you're just beyond hope. And so it's kind of trying to balance that. And the courts and the departments do take that typically very seriously from what I've seen. So.
How do you feel? I know we'd like to just say no.
So I've written up, I guess. Maybe I'd be more comfortable with that.
How about you, Bruce?
Well, I like his proposal. It's sort of groundbreaking in that we're going to have another committee now, so.
I'm fine with the committee.
Yeah,
That's
I know
not-
you're
that's
having
not a big
problems with the end.
No, I'm not saying, I'm just saying,
Yeah,
that, the whole
you know.
proposal is.
Right.
Yeah, I mean, the flip side to your discussion, though, is also true. That while you're looking at it from the perspective of, oh my goodness, these guys that are the worst of the worst technically have, in some cases, slightly less restrictive restrictions. We're also from because when you look at the total of sex offenders as a category as a whole, the 980 folks are, this percentage. I mean, it's a very small percentage of the folks that fall under that category. And so for the bulk of the offenders, the ones that, the guy from Mequon that we just talked about, whose victims were, he would otherwise qualify as a serious sex offender under the statute. The reason why he didn't, I think, without knowing all of the details behind the charging, is because he was also a minor of similar age at the time, and so that saved him from being that. But he clearly is one of the guys that based on the fact that his victim was under the age of 14, if he was under the Chapter 980 program, he would be the worst of the worst, and yet he's not, and so he's under the same general rules as anybody else. And in that circumstance, having the more restrictive rules that we have for the bulk of the offenders makes some sense, I think, because it helps protect the community from the ones that we're realistically going to see. The 980 ones are such a small number that we may never see one within the community. Because typically one of the other issues with 980 is that they try to put them back in the community where they came from. Because the research tells us that when they have a support system of their family and friends and churches and work and all that kind of stuff, that they typically do better. And so they try to put them back in the community where they came from. Now it's in the statute based on counties, so I mean, it technically could be anywhere in the county, but they do try to be a little bit even more specific, that if it's like in Milwaukee County, I would say they probably look more, northern Milwaukee County, southern Milwaukee County, and the city of Milwaukee just kind of keeps their own, is typically how it happens. And so, we might get, somebody from Greendale or Hales Corners or Franklin, but it's going to be it's such a small number that I don't know that you worry about it too much.
Yeah, and see, I don't remember, so if the person did not live in Greenfield before the offense, he or she can still move into Greenfield.
Well, we kept, and that's actually a distinction too. I mean, there are some communities that have gotten rid of the original domicile clause that says, if you weren't a resident at the time that you committed your offense, then you can't come here. We kept that in. That's still a restriction that we have. But that person can also go to the appeals board and say, here's why it makes sense. So, again, recognizing and looking at all of that research that tells you that support network is what really helps. And this was actually a little bit of that case in Mequon too, that where the offense may have taken place outside of the community, if you have somebody that's coming home to be close to mom and dad and the church that he grew up with and, all of his high school buddies and, that support network that he could then grow and hopefully help prevent him from, reoffending, that would be a person that the appeal board could look at and say, yeah, it makes sense, for you to be exempted from this. That's that individualized risk assessment that the courts talk about. So they can look at that and say, yes, this makes sense for this particular offender. But the general rule applies that they just wouldn't, so we have areas right now where, if an offender could move into tomorrow, if they didn't commit the crime here, they still couldn't move there. They would have to get the appeal board to say they could move there.
Say that again? I'm sorry.
Nope, that's all right. So right now, either under our current code or under what's proposed, there are areas within the community that an offender can just move to without any appeal board or anything, that they're just allowed to live there. If they have that, if that original domicile clause applies, then they don't even get to live in those areas. They just don't get to come in at all without the appeal board stepping in and saying, yes, you're okay. So, I will tell you, that there is a little bit of risk there. Certainly if you read the cases and the discussions about concerns about banishment and everything else, certainly an original domicile clause is banishment in some respects. But I think that the ability to utilize the appeal board to do that risk assessment, to make that determination, hey, is this person really going to be better served by coming here? Is this the appropriate spot for him based on all of the factors of that we spell out in the code, and make that decision. I think that the court looks at that and says, no, that's an acceptable method of dealing with these types of offenders because of the harm that they otherwise do represent to a community based on their recidivism rates and everything else. So.
Okay. Okay.
All right. So, are you in agreement or do you,
we're in
and
agreement.
you're okay with it, you said?
It can be 2-1, too, when it goes to council.
Right.
If you want to vote no, that's fine.
I know it's hard to play out and going, I thought I felt one way and then I was going back and forth too on it, but I think all in all, I agree. I'm okay with the changes.
Okay,
All right.
Or maybe I'll vote against it now and then change my mind later.
you can do that.
I can do
You could do it the other way too. You could go along with it now and change your mind at council.
Yes.
I guess certainly, as any of you, either here or even if any of the other members, if Carl or Pam or even the mayor, happens to listen to the recording to try to get a better understanding that the same is true for them. If as you're trying to noodle this out and trying to figure out, hey, does this make sense or not? Give me a call. We'll walk you through it. We'll help. You understand, or
Yeah.
Maybe there's something I'm missing too. I don't pretend to have all of the answers usually. So.
Oh,
Okay.
well, thank you again, Brian. All right. So,
So on this one, I think because we have a specific proposal that's more or less ready to go, we'd probably do a motion to
take
refer
motion?
it to council.
Okay. Would somebody like to make a motion for number 7?
I'll make a motion amending section 1031 and 1032 of the municipal code as it relates to sex offender loitering and residency restrictions, and creating section 135 to create the sex offender residency appeal board.
Okay, and I will second.
Okay?
And then, just
Just
all
a
in
voice
favor?
vote, yeah, that's fine.
Okay, all in favor?
Aye.
Aye. Opposed? Okay, ayes have it.
Okay.
And then, I'll make a motion to adjourn at,
I'll make a motion to adjourn.
all right, at 8:05?
Second.
Okay,
there.
seconded by Shirley, all in favor?
Aye.
Aye. Opposed? We're done. Yeah, that one was a little hairy.
Yeah, very in-depth.
Yes, and thank you.